Good morning. In all these years that I've been doing the bar, which is since before some of you were born, I've done little introductory tapes to a number of the subjects, and somehow I've never gotten around to doing an introductory tape for the materials in property. And it seemed to me that today would be a good day to do so. What I try to do in these introductory discussions or lectures, actually the longest lectures I give, these are, the rest is going over questions and things, is to tell you what I think you ought to be looking for in reading the outline, how you ought to be approaching reading the outline so that you will have an overall picture and then pictures of the parts that are the most important. So I am not going to give a lecture of the length, say, of the wonderful Barbary lecture that goes on for about 9 hours. I'm not going to cover or even attempt to cover many of the details. I will even refrain, although it's very hard for me to refrain from doing too many jokes, but just give you the basic structure and emphasize what it is that I think is most important for you to really get down. And it turns out mostly that's the same for the multi-state MBE questions and for the essay questions in most states. So that when you're studying for doing MBE questions in property, you're studying the very concepts that are very likely to appear in essays and vice versa. And the approach in terms of having the material understood in an organized fashion in your mind, not just memorized, but understood in an organized fashion in your mind, is basically the same. So I have created here a chart. I am not going to warrant that it is perfect. I did it quickly. It takes a lot of time. But on the little chart that you have, it lists various parts of the law of property, and then it lists where you find that appearing in specific MBE questions that I've given or will give in property class number 1, property class number 2, those on Mock Bar 1, Mock Bar 2, Mock Bar 3, Mock Bar 3.5, Mock Bar New, and then a column which will have more things in it than any Connecticut essays and New York property essays, and then the essays that I have in my New York domestic packet. So you're going to see what things are appearing very, very often. Some things appear so often that I've kind of left them out, haven't really put them in, like life estates appear so often. They're not necessarily the main issue, but they're just always there. So I say often, right? Here's how I want you to think about property, and then we'll turn to the specifics. Remember, I said in approaching torts, so that you can have the whole thing organized in your mind, 3 big file drawers. It was torts by fault level, miscellaneous torts, general consideration. And then in your file cabinet of torts by fault level was the intentional torts, negligence, and strict liability, and so forth, breaking it down from those big 3 into smaller parts and ultimately down to the prima facie case and defenses for each of the torts. That's what you need to have mostly ready at hand when you go to answer an MBE question, or even more especially when you go to write an essay question. So that if you can start by saying, in battery, plaintiff must prove, and lay out what the case is, you're off to a great start. So how would I organize property? Property is very different from any of the other subjects. Lots of what seem to be just distinct little separate areas with their own rules, some of them very antique, with antique language like springing and shifting executory interests and stuff like that, and some of them pretty modern in concept like zoning and stuff like that. But it still fits into 3 big filing cabinets, more or less fits. Number 1, we have a large part of what we need to know about property that just has to do with who owns the property. And we're only talking about real property in general in here for the bar exam. A little bit of personal property will not be taken up today. So who owns it, number 1? Number 2, what uses can they or others make of the property? Ownership, use, number 2. And 3, how does ownership get transferred? Pretty much everything fits into one of those cabinets. Ownership, use, transfer. So let's take ownership. A person who is not educated in the law or who at least has not studied property law in detail, may not understand that to own property is not one thing. It's a variety of things that we talk about just in terms of ownership. The first category is what we call present and future interests in the same piece of property. A piece of land can have someone have a present right to the land, present right to possess, and another person might have the right to possess it at some time in the future. Present and future interests. Major topic of discussion, although not as big as some of you may fear in terms of the amount of testing. Present and future interests in the same piece of land. The second big category that is tested all the time, co-ownership. Not only can we divide ownership between now and later, we can divide ownership at any time between more than one person. That is, one person may own the land, or 2 or 3 or 4 persons might own the land at the same time, might either have the present right of ownership or the future right together. This is called co-tenancies and is a second major topic. So present and future interests over time, co-tenancies either in the present or in the future, is the major part of what we've been talking about with ownership. But there are a couple of other things that I'd stick in here under ownership. Fixtures, an area which you're likely to see for no more than 1, maybe 2 questions on the multi-state, and not often on essays, we'll see, have to do with when something that is presently a piece of personal property, something that is not the land you buy in a hardware store or a construction store or somewhere, and you bring it onto the land and attach it to the land in some way. When does that, what was personal property, become so attached to the real estate that it cannot be freely removed from the real estate, but passes when the real estate is sold? It becomes a fixture. So we don't mean the same thing in law by a fixture as we mean in everyday language by fixtures, the bathroom fixtures. We mean a lot more and a lot less by fixtures. And fourth, briefly at least, one may own land in trust for someone else. So we'll talk just a tiny bit about the creation of trusts as it appears on the multi-state. Trust is really a whole separate subject for another day. And then finally, a category that kind of overflows the bounds, landlord-tenant law, because landlord-tenant law does involve present and future interests. When a landlord puts a tenant into possession, the tenant has a present right to possess the land. The landlord has a right to get the land back at some time in the future, so land is divided across time in landlord-tenant law. But landlord-tenant law also tells us about the uses that the tenant can and can't make and obligations that go therewith, so it doesn't totally and neatly fit within just ownership. But those are the 4 big categories for ownership: over time, co-tenancies, trusts, fixtures, landlord-tenant law. We can do the same thing, we'll come back for the next level of detail shortly, when it comes to land use. As soon as you see one person making a use of another person's land or demanding that someone else not do something with their land, you have to think about land use controls. And there are private land use controls that are created privately by owners. The big ones are easements and profits, which are similar, covenants running with the land at law, and equitable servitudes, which are very similar to covenants and sometimes also very similar to easements. So which label we want to attach can be sometimes tricky and difficult. We'll deal with easements. We deal almost not at all with profits, a little maybe, with covenants running with the land at law, with equitable servitudes. But we also need to consider, in terms of land use, a few other doctrines, a few other areas of the law that Barbary separates, puts them way at the end of their outline, but I'd like you to think of them at the same time. Lateral and subjacent support. If 2 people are own land next to each other, do they owe a duty of supporting the other's land when they dig? Or if one person owns the surface, another person has mining rights, does the person who's mining have a right to support a duty to support the surface? And water rights. who has the right to water. Minor subjects, but that appear occasionally with a question, sometimes two, on the exam. And then a really major area of the law pertaining to land use, but not much tested on the bar, very little tested on the bar. Zoning. Need to be somewhat aware of some points about zoning, which has to do with control of land use by the public, and also with the tort doctrines of trespass and nuisance, because they have to do with when an owner can prevent someone else from using his land or misusing his land. And that's all land use, it's all a package. And then finally, an area that most of us, when we went to law school, studied bits and pieces of, but not much, unless we took a real estate transactions course, which most people don't take, and even then you may not have covered all of this. How do we transfer interests in land? And this is a big thing, big subject. Well, one funny little way in which interests in land get transferred, not conveyed actually, is called adverse possession. One person owns it, another person does this thing, whatever it is, that allows him to become an adverse possessor, and lo and behold, land has been transferred in ownership. But as fun, from an intellectual point of view, as adverse possession is, it's not the typical way of transferring land. The typical way of transferring land is by sale or gift. We're not going to talk much about gifts, but gifts kind of fall within some of these things about sales. In order to sell a piece of land, we don't need to have a contract ahead of time, but we almost always, 100% of the time, have a contract first, and then the actual transfer of ownership at some time later. So a substantial chunk of what you need to know on questions that are written from a property perspective on the MBE and on essays has to do with doctrines pertaining to land sale contracts. Number one, of course, land sale contracts fall under the statute of frauds. Number two, we have funny doctrines like equitable conversion and marketable title and all sorts of funny special doctrines that pertain to land use contracts that don't pertain to other kinds of contracts. And then because we're going to come back to this in more detail, I just want the big picture right now. At the end of the contract period, if everything goes well, we should have a deed given by the present owner to the person who is to be the buyer. And we need to know something about what is in deeds, about what a proper description of land would be in a deed. But we also need to know, always tested, that we don't succeed in transferring land unless there is a deed that is executed, delivered, and accepted. And delivery and acceptance are tested regularly, very regularly. We also need to know that in deeds, once someone transfers a deed, there often are promises about the title. What's the state of the title? To what degree is the seller guaranteeing that the buyer is getting a good title? And so we look at covenants of title in some detail. We will need to look at the recording statutes. This is a major area, very heavily tested, because, well, you'll see, if you don't know already, very heavily tested. And finally, in this transfer of land, well, not quite finally, but almost finally, we have wills. Wills did not used to be covered at all in Barbry's property outline because it wasn't covered at all on the multi-state bar examination. Wills is mostly covered in a separate outline, just like trusts is, and I won't say much about wills today. But wills now appear, a few basic wills doctrines now do appear on MBE questions, and so we need to at least think about those in our property context. And finally, something that they test much more now than they used to, security interests in real estate. Remember, we have a thing called secured transactions with personal property under the UCC, a way of protecting and gaining priorities. Well, we have a similar thing with land that I'm sure most of you know quite well, one way or another. know of, but may not know the law of quite well, which is security interests in land, generally mortgages, but other kinds of interests, and who gets priority, what do they need to do to get priority, what rights do they get on account of priority, what does foreclosure look like, and so forth. That's the law of property. It doesn't fit into that many separate boxes: ownership, use, transfer, and each of those comes in some distinct areas, so that when you sit down and you face an outline that's 110 pages of stuff in the longer outlines, I don't know how many pages in the new shorter page outlines that have the same content, probably 150 pages. It's like, oh my God, it's so much. Yes, if you sit down and say, I'm going to learn this, but if you chunk it and say, okay, ownership, what's involved there? Let me set aside a period of time. I'm going to look at the ownership materials, and they run for the first 49 pages of the outline. First half, a little less than half. But you don't even have to say, gee, I'm going to read that 49 pages at one sitting. You can divide it up and say, I'm going to just read the materials about present and future interests. 29 pages of some of the most dreary reading, unless you are into shifting and spring executory interests and rule against perpetuities, but not as much tested as it might be, considering how much space it takes up in the Barbary outline, and I'll try to emphasize that, which is really important for you to know. 29 pages, say you're going to spend about 3 hours reading it, but you're going to know what to focus on. Then, from page 29 in the long outline to 34, co-tenancies, only 5 pages, half an hour or so, but a lot of very heavily tested materials. Landlord-tenant, 34 to 46, about 12 pages, an hour, a little over an hour. Parts of it are very heavily tested, other parts very little tested. Fixtures, a few pages, half hour. And we're done with ownership, but we've divided it into chunks and not said we've got to study it all at once. Rights in the land of another, land use materials, easements, profits, covenants, servitudes, runs in Barbary's long outline from page 49 to 66, 17 pages. I'd say plan on a 2-hour study for that portion of the land use materials. Study the table of contents, then read it, and then the other materials that I've referred to as being part of land use are really at the very end of the outline, page 105 to 110, and I'd go back there and spend an hour, 45 minutes on that. Lateral support, subjacent support, water rights, rights to exclude people from your land, and a little bit on co-ops, condos, and zoning. Probably more than you need on that, but that's land use, right? So you spend several hours on that, knowing exactly where things fit, studying the table of contents first, and then the rest of your time is going to be on pages 66 to 105, 40 pages. That's a very large chunk of the outline, more than a third, on transfer. But again, are you going to sit down and read that in 4 or 5 straight hours? Some of you maybe, but you might be better off chunking it again. Adverse possession, 45 minutes. Conveyancing of land, just the conveyancing materials, about 6 pages on the first part on the land contract, half an hour. Deeds, another half an hour. Delivery and acceptance, another half an hour. Covenants of title, less than half an hour. Recording, big. At least an hour on recording. Wills, very little, half an hour. Security interests, a good solid hour. But look at the table of contents, read what you're going to be studying in that area and figure, okay, this is going to take me an hour, I'll study this chunk and put it all together, okay? That's my recommendation to make it feel more manageable. Let's go to the beginning. The beginning is the material on ownership, right? Who owns land? And as I said, it is not the common sense of ownership, it's a little different from the common sense of ownership. But let's look at my chart where I have included questions. What is tested? And if you look, there's a scattering of questions under ownership on present possessory estates, including fee simples and defeasible fees, which I'll talk about later. Life estates appear all the time, but not usually big issues about them. Future interests on Connecticut essays, very, very, very regular. This is a packet that I created that has 55 Connecticut essays in it, right? I just took them, all it is Connecticut essays involving property issues over the last, that would be 28, 29 years or so, 28 to 29 years, 55 essays. It's about an essay per exam. Some of them may say they're a wills essay in a sense, but the wills is all about present and future interest. So it includes essays that are in part wills and part trust, but are basically present and future interest, but includes everything. So out of this 55, you might notice 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 out of 55 I have classified as involving fee simple determinable subject to a condition subsequent and so forth, whatever that is. That means it comes up a lot. Future interest similarly comes up a whole lot, more often than I've listed there. And then when I'm looking all the way through, other things come up both on the multi-state, on the back of the page. Look at the back of the page. Remainders come up a lot more than I listed. I just didn't break it down. Executory interest more often than I listed in essays. Didn't break it down. That's all part of present future interest. They come up all the time in essays, as you will see. But the next thing, rule against perpetuities, seems to come up about, 1 out of 5 times. That's kind of scary to some people, but that's the way it is. Rule against restraints on alienation, about half as often. And now we're done with ownership. Yes, there are a fair number of essays involving ownership. There are not a tremendous number of multi-state questions involving the issues of ownership. Expect that it's going to be involved in maybe 4 or 5 questions on any particular exam, maybe 6 on the multi-state. On essays, a very good chance that you'll have something involving some of this ownership of present and future interests before we go any further. So what do I mean, ownership, present, future interests? We have a lot of language that at first and even upon reflection may seem kind of ugly, not glamorous, not poetic by any means, that describe interests in property. The reason for this is, if you're not aware of this, it may help somewhat, that our law has been handed down to us since the time of a guy who was kind of like Muammar Gaddafi. His name was William the Conqueror. And like Muammar, he just kind of went over and killed a lot of people and took the land, right? Conqueror. When he conquered the land, he set up the beginnings of a land system that, with tremendous amount of variations, has evolved to what we have today in the United States. And the language used was the language of the time, which was French, kind of Anglo-French language of the law. And things derived therefrom passed on even when English became the actual official language, again, of England after several hundred years. And the terms stayed very similar, very close over hundreds and hundreds of years for stuff that we presently use today. So you may study history, and actually it can be very fascinating, the history of how we got to call a thing a fee simple absolute and how we got to call a thing an executory interest. Or you can just say, okay, there's a certain amount of language, I just have to know what it looks like. But you want to use the right words. You will get credit for using the right words. It will help you lay out what we've got. When you have a multiple choice question or an essay question with words in quotation marks that say that someone, let's call that someone O, owns land in fee simple absolute and conveys land to Jones for life, and then to Smith and his heirs, or to Jones for life, then to Smith's children if they outlive him, any kind of language like that, they're asking you to classify. No matter what, you have to decide what this language means, what terms we're going to put on it. Once we label it properly, then we can figure out what the significance of it is. Now, I'm thinking that I could give a detailed lecture going through this that would probably take a good full hour, or I could save that detailed lecture and do it separately, and I think that is a better plan, to do that as a separate tape just on present, future interests and rule against perpetuity. So I'm going to do a limited introduction to it today. Let's start with that thing called a fee simple absolute. Those are the exact words, fee simple absolute, which means we can have things other than a fee simple absolute, or it wouldn't make any sense to use those words. We can have a thing called a fee tail. You don't even want to know about it. Doesn't exist, don't worry about it. You can read what Barbary says, but it's basically out of existence, not going to be tested in the United States by any rational bar examiner. So fees are all simple today. But then why fee simple absolute? How could it not be absolute? Fee simples, if they're absolute, go on and on and on indefinitely, because all that we mean by a fee simple absolute is that the person who has it, owner, can transfer the same rights that he has to another person while he's alive. I have a fee simple absolute. I transfer it to A, the whole thing. He has a fee simple absolute. A, during his lifetime, does not transfer his fee simple absolute, but dies. He leaves his fee simple absolute in his will to his eldest daughter. She now has what? A fee simple absolute. She stays there for her life. She never sells it. She dies. She doesn't have a will. Who gets it? Whoever her heir is at common law, common law heir is under the statutes of the state, and so forth. The land stays as a fee simple absolute. Somebody has that fee simple absolute, whether in present or future, indefinitely, and the only time the fee simple absolute will ever come to an end is if the person who has the fee simple absolute dies without a will and with no heirs, in which case the fee simple absolute escheats, we call it, to the state. So the fee simple absolute lasts potentially forever and ever and ever, especially since one can will it or have it pass under the laws of intestacy and so forth. So when is a fee simple not absolute? We have several categories, and if you notice on my little chart, they are tested on the MBE pretty regularly and on essays in Connecticut very regularly. We have three basic concepts: a fee simple that is determinable, a fee simple that is subject to a condition subsequent, and a fee simple that is subject to an executory interest. Occasionally, even, for God forbid, we have a fee simple determinable subject to an executory interest. But in any case, notice none of those did we use the word absolute. We replaced the word absolute with something that indicated that it was going to come to an end. It's going to cut short a fee simple. What can cut short a fee simple so that it's not absolute? Well, several different things. We need to look at the language. And we could turn to any of these essays that I've got listed here, and we will later, 2, 3, 24, 28, 32, 38, and see over and over and over again that on essays, Connecticut loves to test this, and it does appear quite regularly as a question or two in the MBE. They're going to use language that the person who has a fee simple absolute transfers, quote, to A and his heirs, so long as the property is not used for the sale of alcoholic beverages, so long as the land is used only for farming purposes, to A and his heirs while it is used for farming, to A and his heirs during the period when no alcohol is served on the premises. This is a matter of memorization of what term to use in what context. A fee simple is made determinable by use of language of time, of duration, to A and his heirs so long as. Let me back up a step. I didn't mention the traditional way of creating a fee simple absolute was to use the phrase and his heirs. To A and his heirs did not mean the heirs were getting an interest, simply meant that A was getting a fee simple absolute. It was a way of saying it. It used to be required that we use the phrase and his heirs to create a fee simple absolute. In modern law, it's not required, but it's often done. To A and his heirs, so long as the land is not used for the sale of alcohol, creates a fee simple determinable. We'll stop there for a moment. How else could a fee simple not be absolute? It could be subject to a condition subsequent. Same thing, but we use different language. To A and his heirs, but if the land is ever used for the sale of alcoholic beverages, then I, grantor, retain a right of entry. To A and his heirs, provided that if the land is ever used for the sale of alcoholic beverages, I retain a right of entry. So we need language of condition, conditional kinds of language. Provided that, but if, and then retention, explicit retention of a future interest called a right of entry or a power of termination in the grantor. And yet there's one more way in which we can have a fee simple that is not absolute. We can have a fee simple that is subject to an executory interest. Example, to A and his heirs, so long as no alcohol is served on the premises, then to B and his heirs. That looks an awful lot like what we called a fee simple determinable before. Yes, but it's now subject to going over to a third person, someone other than the grantor. And if the future interest is in someone other than the grantor, as strange as it may seem, we call it an executory interest, whereas when we only have a fee simple determinable, future interest in the grantor is labeled a possibility of reverter. Isn't that beautiful? If we have a fee simple determinable and the future interest is in the grantor, it does not even have to be stated. It's automatically implied. If I have a fee simple absolute, that's 100 pieces, and I give away everything except keeping it, getting it back after alcohol is served, then the thing that's not given away is retained in the grantor, but we don't say it's a retention, we say it is a possibility of reverter. Fee simple determinable followed by possibility of reverter automatically. But if we have a fee simple determinable and then we purport to give the future interest to a third person in the same document, we put the label executory interest on that third person's interest. Why does this matter? Matters because executory interests are subject to that loveliest of all concepts, the rule against perpetuities. Possibilities of reverter are not subject to that most beautiful of all things, rule against perpetuities. So we have to put the right labels on. Fee simple subject to a condition subsequent followed by a right of entry can be changed in form to the following. To A and his heirs, but if alcohol is ever served on the premises, then to B and his heirs. Now we have something that looked just like that fee simple subject to a condition subsequent, but instead of being a right retaining or having a future interest as the right of entry in the grantor, instead we give the future interest after the expiration of the fee simple. We give it to whom? To a third person. So what do we label it? We put the label executory interest on it. So any of these things that cuts short a fee simple is going to be followed either by an interest retained in the grantor or devisor. If it's retained in the grantor after a fee simple determinable, it's called possibility of reverter. If it's retained in the grantor after a fee simple subject to a condition subsequent, it's called a right of entry, power of termination. But if the grantor transfers the future interest in the same document to a third person, then it's called an executory interest. This appears on Connecticut essays with such regularity that one would make a grave mistake not to get this down and really clear. Now, of course, what they're going to do on the test is they're going to make the language ambiguous and uncertain. So you're going to, well, this could be a fee simple determinable, but they didn't use the right language. It appears to be a right of entry, but they didn't use the right language, and so forth. And you'll see this as we look at a bunch over the course of examples of this, because it comes up often enough. You want to walk in saying, I'm ready for that essay if it appears. So much for that kind of present and future interest. We'll come back to the rule against perpetuities later. But suppose that the person with the fee simple absolute makes a different kind of grants to a person for their lifetime. We have a thing called a life estate. O has the fee simple absolute, and he makes a grant expressly to A for life, or implicitly sometimes A gets a life estate. However the life estate is created, it can be a life estate measured by the life of the person who owns it, or measured by the life of someone else. To A until B's death is a life estate per outre V. That concept appears not often tested. The most important thing with life estates is that life tenants only have the right to possess from the time their interest is created until they die, and beyond their death they have no rights. And this limits what they can do with the land in order to protect the interest of whoever is supposed to get the land after their death. All sorts of different labels for the person who can get the interest after their death. Basically, they are remainders in third persons or reversions in the grantor. I grant to A for life and say nothing more. It's a life estate in A, and I've retained a reversion. I say to A for life, then to B and his heirs, it's a life estate in A, and a remainder in B and his heirs. All kinds of remainders we're not going to talk about right now. But what's the relationship between the life tenant and whoever owns the land, the future interest in the land? That is our doctrine of waste. And that's always tested. The life tenant cannot do things that change the land in a way that's injurious to the future interest holder, generally. But that's very oversimplified. The life tenant has to maintain the land in its present condition, do repairs, pay taxes, and so forth, but not beyond the income that the life tenant actually gains from the land or the rental value of the land. If the costs of these repairs exceed the value of the land in its present use, life tenant doesn't have to pay them. And the future interest holder has to pay anything that is for a longer term. Issue that comes up a lot, there's a mortgage. Land is left in a will to A for life, then to B and his heirs, and there's an existing outstanding mortgage upon which interest is due and principal is due. Life tenant has to pay interest so long as the land is worth the amount of the interest, but the life tenant has no duty to pay the principal. The remainder people have to pay the principal, but they don't really have to pay it. They have to pay it or be subject to foreclosure, okay? Those kinds of relationships between life tenant and remainder person are always tested. It is important for you to be aware of them. If they're always on the MBE, they are not often on essays. Be aware of the doctrine of renunciation. A person with a life tenant can renounce it. Appears from time to time. But now I want to talk about future interests. As you see, I'm talking about the things that are most heavily tested. Future interests. We have a limited number of labels that we use for future interests. And you want to know what these labels are and what they look like and use the right label at the right time. There are 3 names for future interests that are retained in a grantor, or if it's in a will, in a devisor, the person who leaves land in a will. There are 3 labels and only 3. No other. There is a thing called a possibility of reverter. That is the name of the future interest that is retained by the grantor or devisor when he gives away, transfers a fee simple determinable. Period. They go together. There is a thing, right of entry power, or also called power of termination, that follows a fee simple subject to a condition subsequent. it must be expressly stated in the deed or the will, and is the name of the future interest retained by the grantor or devisor, meaning they have the right to get it back at some time in the future if that condition occurs. And we have one other, and that's it, future interest in a grantor, and it is labeled a reversion. And it is the name for a future interest in the grantor after a life estate or after a leasehold estate, landlord-tenant law. The landlord has a reversion right to get it back after the tenancy is over, or after a life estate is over. It's called a reversion. No other labels for future interest retained by grantors or devisors. But if the grantor or devisor creates a future interest, that is a right to get possession of land at some time in the future, in someone other than himself, it is given a different set of labels, and mostly it becomes subject to the rule against perpetuities, which was not true of future interests in the grantor. Let me start by saying this is silly. It makes no logical sense in the modern era to say if we put the one label on it, it's not subject to the rule, and this other label on it is subject to the rule, but that's the way it is. We can have in persons other than the grantor future interests that are labeled either remainders or executory interests, and that's it. They're going to be different kinds, but executory interests only exist when they're following a fee simple that is cut short in some way, or follow some gap in ownership and spring out again in the future. Shifting and springing executory interests, which you will read about, they are subject to the rule against perpetuities. Generally, interests that cut short an interest in a fee simple determinable, a fee simple subject to an executory interest. There are also remainders, as I said, and remainders can be in devisees, people named as such or provided as such in wills or in deeds, and those remainders are divided into two groups. So we have executory interests and remainders. Now our remainders get divided into two big groups. We have vested remainders and contingent remainders. Again, not beautiful language, but you want to use it correctly. It appears all the time on the MBE. You got to pick the right label. And it appears very often in language in essays, and you want to put the right labels on it. A remainder is contingent if at the time that we are classifying it, we don't know who's supposed to get it. The name of the person is not yet ascertained. In fact, the person may not even yet be born. Or if there is stated in the document a condition precedent. We have a named person, but there's a condition precedent to that person taking possession. Examples: to A for life, then to A's surviving children. It's not all of A's children, it's to A's surviving children. So there's a condition precedent. A's children must outlive A in order to get the future interest. In fact, maybe A has no children, so then it would be contingent because we don't have anybody. Or maybe A has 2 children but might have more, so it's contingent also because more might come into being. Contingent on either ascertaining who the people are or contingent upon a condition being met makes the thing a contingent remainder. Hundreds of examples, but they're all contingent remainders. To A for life, then to A's first child to reach age 21. And if no child at that time has reached age 21, at the time we're classifying it, then it's contingent. If he already has a child who has reached age 21, then it's vested. To A for life, then to B if B has graduated from law school. If B has not yet graduated from law school or not even gone to law school, then B's remainder is contingent on his going to and graduating from law school. If that doesn't happen, then we have to have a future interest to fill in for that contingent remainder if it fails, and that's generally going to be a reversion back in the grantor because he didn't give the whole thing away. It's only a contingent remainder. So what makes a remainder vested? The opposite. A remainder is vested if we know who's going to take it, the person is named clearly, and there are no conditions precedent to that person taking other than the life tenant dying. To A for life, then to B and his heirs. We have the named person, B. All we need is a name, B. And there's no condition for B's remainder other than he has to wait till A dies. What if B dies before A? Fine, he had a vested remainder. He can sell it. He can leave it in his will. It's vested. It's his. It's property. It's the right to get the land upon A's death. It's vested. So, is that the end? Almost. But we can have the dumbest of all possible things, a vested remainder that is subject to divestment. Oh my God, why? To A for life. Then to B and his heirs. So A has a life estate, B has a vested remainder, comma. But if B ever moves to the state of Texas, then to C and his heirs. We have something that would cut short B's interest and shift it over to another person. So B's interest, because it says then to B and his heirs without any intervening language, is a vested remainder, but it can be cut short and go over to a third person. That third person's interest would be an executory interest. So B has a vested remainder, but it's subject to divestment. Subject to divestment means we now have a future interest called an executory interest. Very rarely comes up, just mentioning. But the common one is, that you need to be aware of, the vested remainder subject to open, also called subject to partial divestment. Examples all over the place. To A for life, then to B's children. B, at the time of this grant, has 2 children, C and D. Since it says then to B's children, and C and D already exist, their interest is vested, and if they die, that passes through their will or whatever. But B may also still have more children, so the interest of C and D might be decreased by adding people to the group, so it's subject to becoming smaller, subject to the class opening. And therefore, it is subject to the rule against perpetuities. In sum, as you read through this, you're going to see that there are, once you put the right labels on those future interests, and you have a fair chance of having a question like that on the multi-state and a fair chance of having a question like that on essays, is you put the labels on. Present interest, future interest. Future interests in third persons are either third persons are either in the grantor, let me rephrase that. Future interests are either in the grantor, in which case they are reversions or possibilities of reverter or rights of entry, or they are in third persons, in which case they are either executory interests or remainders. And if they're remainders, they're either vested or contingent remainders. And if they're vested remainders, they're either absolutely vested or vested subject occasionally to complete divestment or vested subject to open. Once we put these labels on each interest in the language, which is not fun, but you want to do automatically, then you know that there are 3 things that are subject to the rule against perpetuities. If you've put the label executory interest, contingent remainder, or vested remainder subject to open on any of your future interests, and only if you've put one of those labels on your future interest, then you want to say such future interests are subject to the rule against perpetuities. You do not need to understand the rule against perpetuities in all of its glorious detail and trickiness, but you can get pretty far if you can just sort of state the rule. No interest is good unless it must vest, or fail to vest within some life or lives in being at the time of the creation of the interest, plus 21 years, plus periods of gestation, period. When I get to doing my longer tape on classifying estates and future interests, I will go through that in detail, but that's what the rule says. Applying it is the tough part, of course. Okay. That is what I want to say about present and future interests. I want to leave it at that. Mentioned briefly, there is a rule called the Rule Against Restraints on Alienation that has appeared fairly, not very often on the multi-state, occasionally, but has appeared 5 or 6 times in Connecticut essays out of 50, about 1 out of 10. Not a lot, but it's nice if you recognize it when it appears. If I own the fee simple absolute and I transfer it to somebody else, they're supposed to be able to transfer it in general. If I put restraints on the ability of someone to alienate what I've transferred to them, some of those become simply unenforceable and others are enforceable. Read about the Rule Against Restraints on Alienation. Again, I will take that up in more detail in the more detailed lecture on present and future interests. Concurrent estates. Notice when we get to concurrent estates, and you're looking at my chart, how many essays pertain to things relating to these concurrent estates. Lots and lots and lots and lots and lots. And it's a relatively few pages in your outline, but it appears particularly in essays, always on the multiple choice, by the way, also. I'd say for the amount of material that you have to learn, it's relatively more important per page. Concurrent estates mean that more than one person has the right at the same time, either in present ownership, we can have co-tenancies in a present interest, or co-tenancies in a future interest. More than one person owning the same piece of land at the same time. We have 3 kinds of co-tenancies that we talk about in modern law. They are joint tenancies, which are very heavily tested. We have tenancies by the entirety, which are much less heavily tested, although you note, if you're looking at my chart, that they have appeared fairly regularly in New York domestic relations questions, of all places, because they involve marriage or require marriage, and tenancies in common, which are also very, very regularly tested, right? So we have these 3 areas that are very regularly tested, 2 that are very regularly tested: joint tenancies, tenancies in common. Much less regularly tested are tenancies by the entirety. Joint tenancies are properly created by language saying to A and B as joint tenants with right of survivorship. In modern law, you are supposed to be express in creating a joint tenancy with right of survivorship, and there are many cases holding if you say to A and B jointly, that's just a tenancy in common. It's got to be to A and B as joint tenants with right of survivorship, that being the key. What do we mean by right of survivorship to start with? We mean that if A and B continue as joint tenants until one of them dies, automatically the other one owns the whole thing. The one who died cannot leave the land to someone else in his will. It does not pass under the laws of intestacy to his heirs. If there are 2 joint tenants and at the time one of them dies, at the time of his death, the other one just owns the whole thing automatically. If there are 3 joint tenants and one of them dies, the other 2 now become 50-50 in their ownership. So this right of survivorship is very, very important. It's done on purpose so that one does not have to pass the land by will or anything else. It's automatic. However, to create a joint tenancy requires what are called the 4 unities. It's not so easy to do it. Typically, traditionally, I cannot own a piece of land and transfer it to a second person and myself and thereby make us joint tenants. It can't be O to O and A as joint tenants with right of survivorship because I already own it. I would have to transfer it to a straw person, O to B, and then B to O and A as joint tenants with right of survivorship. We need an extra piece of paper. Why? Because the joint tenancy must be created at the same time, in the same document, in equal shares. Everything has to be the same. We can't have as joint tenants with 60% in O and A and 40% in B. Can't be different percentages. Has to be equal ownership, equal right to possession, at the same time, in the same document. The unities. If any of them don't exist traditionally, we don't have a joint tenancy. We would just have a tenancy in common. There are sometimes modern statutes that change that and allow for other things, and be aware they occasionally appear but not often. If we actually created a joint tenancy, then very important doctrine comes up. And if you look at my little chart of essays, number one, it appears on the multi-state, almost always going to be a question or two on the multi-state involving a doctrine called severance. Do not confuse severance with partition. They sound like they are similar, and any two things that sound similar are likely to get us confused at first. You sever something, you partition it, you cut it up, you divide it up. No, but they mean different things, okay? So be aware of their meaning. Severance is something we apply to joint tenancies when we are doing something that simply destroys the right of survivorship, but otherwise leaves the people in co-ownership. It simply changes a joint tenancy into a tenancy in common in the same piece of land, an act by one or both of the joint tenants that destroys the right of survivorship. And we'll talk about what does that in a minute, right? That's a severance. But let me compare it to partition. Partition is when we actually have co-tenancy and we split the physical land into, let's say, two parts if they're two joint or co-tenants. We split it into two parts. The two of them transfer to each other. I transfer my interest in the north 10 acres to you by a deed. You transfer in a different deed your interest in the south 10 acres to me. Now you own the north 10, I own the south 10. We had co-tenancies and we've now physically split the land, or we sell the land and split the proceeds, that's a partition, or we go to a court because we can't agree and bring an action called an action for partition, in which we ask the court to divide the land physically between us or to sell the land and divide the proceeds between us. That's different from severance, which only destroys the right of survivorship in a joint tenancy. So what do we mean by severance? We mean an action by one or both of the joint tenants that's so inconsistent with their joint tenancy that the courts will say there is no longer a right of survivorship. If one of the joint tenants transfers his interest to a third person, A and B are joint tenants with right of survivorship. A transfers her interest to C. Do we now have a joint tenancy between B and C? Does C get the same thing that A had? No. The transfer destroys the unities. It is now severed, and now B and C are tenants in common. They are not joint tenants when there's a transfer. But that's the easy case. What if A mortgages the property? That is, gives a mortgage and borrows money against her interest in the property. A mortgage can be treated as either the giving of a title in the property or as a placing of a lien on the property. If it's treated as just a lien, it does not sever the joint tenancy. But in those states, which are apparently not many at this point, that say giving a mortgage is giving a kind of a title, then the giving of the mortgage by one of the two joint tenants destroys the right of survivorship. If both tenants, both joint tenants, mortgage the property and give a joint mortgage, then it does not sever the right of survivorship. Interesting questions. What if A and B own the property as joint tenants, and A enters into a contract to sell her share to B? Does the contract to sell sever the right of survivorship? Well, why would a contract do it? It's not a conveyance, is it? Well, see what we take up much later, the doctrine of equitable conversion. Under the concept of equitable conversion, it's as if the land has already been transferred and the money received, And so many states say that is enough to sever the joint tenancy. So if A dies before carrying out the contract, there is no longer a joint tenancy. It has been destroyed. C has the right to enforce the contract and become a tenant in common because the contract itself severed the joint tenancy. What if both tenants entered into a contract to sell? Most states would say that does not sever the joint tenancy, but a few might say that it does. That at least is an issue to consider. So there are so many ways. You want to study what they have in the outline about severance with great attention. It's not much, and it comes up very often on multi-state and on essays. Tenancy by the entireties can only be held by people who are married, can only be created expressly in the deed, saying to A and B, husband and wife, as tenants by the entireties, and so it requires all the same unities as a joint tenancy, plus the two people holding it must be legally husband and wife. As such, they cannot as easily destroy that right of survivorship. Severance is much harder between married folks and generally comes by agreement or divorce. Otherwise, one of the tenants by the entirety dies, the other automatically owns what's left. Tenancies in common. Any other time that two or more people are given a present or a future interest in land, they are just tenants in common. Anything that doesn't fit one of those other categories is in the big catch-all, tenants in common. It can be in a present estate. It can be to A, B, and C in fee simple absolute. It can be to A, B, and C for life. Or it can be to A for life, and then to B, C, and D, and their heirs. So the present interest could be in co-ownership, or a future interest could be in co-ownership. It's just that more than one person owns at the same time. So how is it different from the joint tenancy? Number one, we don't need the four unities. They can be created at different times. Number two, there is no right of survivorship. A, B, and C, to A, B, and C and their heirs creates a fee simple absolute, the use of the phrase and their heirs, A, B, and C and their heirs, and C dies. A and B don't now own the whole thing. C has the right to transfer it by will, or otherwise it passes under the laws of intestacy to whoever is C's heir at law. C can transfer it during his lifetime to D, and D becomes a co-tenant with A and B. It's now A, B, and D. So very different. No severance, no right of survivorship with tenancies in common. Nor do they have to be equal in percentage of ownership. It can be to A 25%, B 25%, and C 50%. They can have different proportions of ownership, which will have that effect when the property is sold as to what share of the proceeds they should take. But you need to also be aware, and notice on my little chart, tested 3 or 4 times on essays, and fairly often coming up in some form in essay question, in multiple choice questions, possession, use, rents, expenses, how are they handled? If 2 or more people own property at the same time, they may just do everything by their agreement, but what are their obligations to each other? Number one, every co-tenant has an equal right to possession. So I have a right to live there. Everybody else who's a co-tenant has a right to live there. None of us can exclude the other. But if we do something that makes profit, we generally have to account to our other co-tenants for the profit. If we encumber the property, we're responsible for the encumbrance that we made. There is among co-tenants a concept called ouster. When we get to adverse possession, how could one co-tenant ever adversely possess against another co-tenant? Only by a thing, beautiful term, ousting, only by making it clear that he or she is claiming the right to exclude the other, throwing all their stuff in a car and lighting it on fire, as in waiting to exhale. Good way to show that you're ousting your other co-tenant. And then when the property gets sold, how do we share the proceeds of the sale? What about expenses that were made by one of the co-tenants? Are they entitled to compensation for their share of expense, what expenses they made in repairing, improving, and so forth the property? You want to read all of that in detail, because these relatively few pages on co-tenancies, common interests, are tested with great regularity. We are now going to take a short break.